is my pleasure to welcome you to the first session of our permanent seminar on human rights and global economic governance. The objective of the seminar is to explore the policies, institutions, and practices that shape human rights protection in the global economy. This year, we will hold 5 sessions, and our subject matter are the challenges of the US-Mexico relationship in the Trump II era. Today, we have with us Professor Ariadna Salazar from the Iberoamericana University and Professor Javier Dondé from the University of Baja California Sur. Professor Salazar is a great expert in human rights and criminal justice, and Professor Dondé holds a PhD in international criminal law and is a researcher level 3 from the Mexican National System of Researchers. We will start with the exposition of Professor Ariadna Salazar, who will analyze the right to asylum and migrant detention according to the challenges and perspectives in the face of government changes in Mexico and the US. Professor Salazar, please, the floor is yours. Your microphone.
Sorry, thank you, Virdzhiniya. I'd like to speak briefly of the right to asylum and the detention of migrants, challenges and perspectives in the face of government changes in Mexico and the US. It is important to highlight the right to asylum, the treatment of migrants, and the respect of human rights are topics that must be urgently considered. Significant political changes have recently occurred as the presidents of Mexico and the United States changed in the 2024 and 2025, respectively. This is concerned over promises made by President Donald Trump regarding migration, especially regarding the protection of human rights. I'd like to briefly speak today regarding 3 areas. 1, the effects of restricting the right to asylum in the US. 2, the effects of irregular migration in Mexico, considered a transit country to the US. And 3, the challenges of the new humanitarian crisis resulting from it. First, let's analyze the restriction of the right to asylum in the United States. This is a legal mechanism through which a migrant can access international protection in another country, known as refugee status. Who has the right to obtain refugee status or asylum? The answer is all those who are at risk of serious harm and whose life or freedom is threatened due to their race, religion, nationality, membership in a particular social group, or political opinion, and who are in danger in their home country. The US has been a part of the Refugee Status Protocol since November 1st, 1968, and is therefore obligated to respect it. In addition, it is required to respect the human rights of people in irregular migratory situations. The right to seek asylum is also guaranteed by US federal law. It is important to note that during the 2024 election campaign, Donald Trump not only promised the reinstatement of some of his previous immigration policies, such as building a big wall on the southern border, but also introduced new proposals to tighten and restrict immigration to the US. There was of conducting the largest deportation of migrants in American history. In the president's statement about Operation Aurora, he referred to Eisenhower Operation Wetback of 1954, which resulted in unnecessary deaths and where logistical difficulties led to the quick end. Since then, the immigration system has changed, and a judicial decision is now required to validate the violation of immigration law. People return to their home countries after such decisions are considered deported, returned, or removed. The process guarantees that after an expulsion order is issued or voluntary departure is granted, the person can appeal within 30 days. This system includes expedited removals carried out by the Department of Homeland Security, DHS, of immigrants who have just crossed the border and entered the country. In terms of human rights, issues arise when deportation of migrants are conducted without due process and without the opportunity to demonstrate that they may be eligible to remain in the country, which can lead to errors and deport or cases where they have the right to asylum. Amnesty International are conclude in its recent report that the right to asylum at the US-Mexico border is non-existent in violation of the national and international human rights obligations of the US. During the pandemic, under the pretext of public health risks, the Title 42 order prohibited non-citizens from entering via land, thereby preventing asylum and refuge requests. This was supported by Mexico through the Stay in Mexico program, where thousands of asylum-seeking migrants must wait for a decision. Since taking office, Trump's signing of executive orders began to implement a migration policy affecting immigration rights, such as 1. The right to request asylum and international protection. Everyone fleeing persecution or violence has the right to request asylum in another country. Second, 2. The right no refoulement. No migrant should be returned to a country where their lives or risks of persecution are endangered. And 3, the right not to be arbitrarily detained. The detention of migrants should be an exceptional measure and only for legitimate reason, respecting their dignity and rights. Expedited deportation seek to have migrants deported without a court hearing if they do not request asylum. If the migrants subject to expedited removal request asylum, they must pass an initial evaluation with an officer to avoid deportation and continue with their case in the immigration judicial system. Trump mentioned expelling 15 or 20 million people. The migration policy is similar to the previous administration, and the guarantees to request asylum are reduced. Within the humanitarian program, there is a selection of countries to request asylum. At the beginning of his mandate, the possibility of seeking asylum was closed, even to those with prior appointments. There is concern that in the case of mass detentions, families, children, and people who, due to complex and often violent situations, cannot have their rights to asylum recognized. In the immigration system, in terms of foreign deportation in different administrations, the Obama administration, known as the deporter-in-chief, deported the most immigrants, with an annual average of 385,000 people, followed by Trump in his previous term with 298,000, and Bush 2001 to 2009 with 251,000 deportations. It is evident that the persecutory practices in that country, both at the border and inside the country, have led to an increase in deportations, arbitrary detentions, and the denial of access to the right to asylum, as well as the right to due process. In Mexico, 4,000 deported people were received in January. A statement by the Mexican President Claudia Sheinbaum emphasized respect for human rights, mentioning that she is prepared with a containment plan, highlighting the importance of informing migrants about their rights to prevent arbitrary detentions. The internal problem is not only relates to the reception plan, but also to the increasing militarization on the border by the Mexican government. The National Guard is performing immigration authority functions that is not prepared for, putting migrants in extremely vulnerable situations. In addition to the internal problem with cartels, organized crime, and the severe issues with Mexican immigration authorities, at the National Institute of Migration Detention Centers, which mainly affects migrants from Central America, the lack of respect for detention deadlines due to administrative issues have led to their treatment being more detrimental than even a criminal process. In 2023, a decision by the Mexican Supreme Court ruled that migrants should be released within 15 days if their migration process is not resolved. The security problem for migrants is very serious and affects not only the migration rights, but also their right to life, bodily integrity, and health, as well as the risk of being captured and exploited or becoming victims of crimes. Due to this high level of vulnerability, and this evasion of Mexican authorities, migrants are forced to take very risky routes where they are often captured by organized crime or drug cartels that operate through the country. This might lead to human rights, and unfortunately, Mexico does not respect to protocols of protecting people in these cases. In conclusion, the relationship and cooperation between Mexico and the United States must be strong, transparent, and collaborative to ensure that the human rights of migrants are respected without compromising the security of sovereignty of both countries. Regarding U.S. migration policy and its impact, not only on migrants, but also on political and economic relations between both countries, it should be oriented toward a deep understanding of asylum policies in the U.S., the treatment of applicants in Mexico's role as a key partner, and implementing these policies. Mexico must resolve internal issues of violence, impunity, and corruption with urgency. Thank you.
Thank you very much, Professor Salazar. We can see the huge challenges that implies human rights protection during the current migration crisis. And we can see both countries, the US and Mexico, manifestly disrespecting all the legal framework on migration. And now it is the turn of Professor Javier Dondé. Javier will analyze the return of the practice of extraterritorial abductions in Mexico, and he will also make some reflections on the El Mayo Zambada case. Professor Dondé, please, the floor is yours.
Thank you, muchas gracias. Bueno, yo he decidido dar la plática en español porque creo que estos temas requieren de una difusión más amplia en el idioma español. Efectivamente, hemos visto en esta nueva era Trump una tendencia en materia de extradición que no habíamos visto desde hace varios años, yo me atrevo a decir décadas. Y se da esto en dos fenómenos distintos. Uno, el secuestro transfronterizo, y lo digo entrecomillado porque no sabemos bien a bien qué pasó, del Mayo Zambada, y la entrega, ahí sí tenemos más claridad de lo que pasó, de estas 29 personas vinculadas a la delincuencia organizada, ¿no? Entre ellas, por supuesto, Caro Quintero, que pues la DEA ya lo tenía en el ojo durante varios años. El caso del Mayo y los dos escenarios tienen repercusiones diferentes y son escenarios de hecho y jurídicos distintos, me parece. En el caso del Mayo, la verdad es que no sabemos bien qué pasó. Un primer escenario posible es que se entregó, pero parece ser que eso ya no es tan viable, no es poco probable en virtud de este reclamo que hace al gobierno mexicano para que sea retornado al territorio nacional y ser juzgado aquí, en México. Los otros dos escenarios que están más vinculados a los secuestros transfronterizos sería que lo engañaron, y digo que lo engañaron porque parece ser que no hubo una detención con uso de la fuerza, ya sea por parte de la DEA, por parte de particulares, se menciona mucho a los chapitos, o una combinación de las anteriores, ¿no? Esto sí sería un secuestro transfronterizo porque en la práctica internacional y extranjera, el secuestro transfronterizo se puede dar a través de una detención que implica el uso de la fuerza o a través de los engaños, ¿no? Entonces, aquí estaríamos claramente ante un escenario de secuestro transfronterizo. Ahora, en materia de política exterior y política internacional, ¿qué implica esto? Bueno, de entrada, si algo positivo le podemos decir de la experiencia del secuestro transfronterizo de Álvarez Machain, ya en la década de los 80, es que hubo una especie de tregua entre Estados Unidos y México, en virtud de la cual no habría más secuestros transfronterizos, o por lo menos no sin la autorización de México. ¿A qué me refiero con esto? Que muchas veces, y esto está documentado a lo largo de todos estos años, para evitar la extradición, un proceso de extradición, las personas eran llevadas a la frontera y literalmente las empujaban y llegaban al otro lado, ¿no? Y esto es de ida y vuelta, no es recíproco. También muchas personas buscadas por el gobierno mexicano también eran entregadas de esta manera. Pero aquí el punto de política criminal internacional, si se quiere ver así, es que había un entendimiento entre los dos gobiernos. En el caso del Mayo parece ser que este entendimiento se rompió. se rompió y decidieron, quienes hayan participado de la detención, que debían de mantener al margen de la discusión al gobierno mexicano. Si esto es por una pérdida en la confianza o por algún otro motivo, eso también entra dentro del campo de la especulación, pero lo cierto es que no participó el gobierno mexicano, lo cual es distinto a lo que ocurrió con los 29 entregados. Ahora, un poquito de análisis jurídico. Durante todo el evento del mayo se ha especulado sobre la legalidad de los secuestros transfronterizos. En los secuestros transfronterizos entran dentro de un área gris del derecho penal, del derecho procesal penal y del derecho internacional penal, en donde son acciones que no están prohibidas. ¿Sí? No les está prohibido a los estados cometer secuestros transfronterizos. Y aquí hay amplia jurisprudencia nacional de tribunales estadounidenses, británicos, canadienses. Parece ser que es una figura muy propia de los sistemas anglosajones, aunque no exclusiva, en donde básicamente no se hace o los jueces no están autorizados para determinar cuáles fueron las condiciones de la detención, ¿no? Siempre y cuando media una orden de aprehensión, detención o su equivalente. Y es el único punto legal que analizan los jueces. Y esta figura se ha llamado, se le conoce por el latinajo de male captus bene detentus. ¿Sí? Entonces, esto que por lo menos en lo que yo había visto en estos últimos años, parece ser que es una práctica que había caído en desuso, por lo menos en la relación México-Estados Unidos, hasta que se dio el tema del Chapo. Ahora, es muy cuestionable desde mi punto de vista y desde el punto de vista de los derechos humanos que simple y sencillamente no estén prohibidos los secuestros transfronterizos, porque es una manera de evitar los procesos de extradición que con todos sus defectos sí proveen a la persona solicitada de ciertos derechos, incluso algunos derechos humanos. Voy a entrar en detalle a esto cuando veamos el caso, cuando analice el caso de los 29 entregados. Y en realidad a las personas se les ve como fichas de cambio, ¿no? Como objetos no sujetos de derecho, en donde las relaciones internacionales, las relaciones bilaterales son más importantes que los derechos, incluso los derechos humanos de las personas que están siendo solicitadas. Es por eso que México en su momento, durante el sexenio del presidente Vicente Fox, propuso un protocolo para, en realidad no es un protocolo, es un tratado autónomo, independiente del tratado de extradición entre México y Estados Unidos, en donde se prohíben textualmente los secuestros transfronterizos. México lo firmó, lo protocolizó, fue aprobado por el Senado, pero Estados Unidos simplemente lo firmó. Claro, no tenía mayor intención de protocolizarlo, de celebrarlo y obligarse a no volver a secuestrar a las personas, pero de facto, como mencionaba, lo hicieron, o por lo menos lo hacían, los secuestros eran consensados entre los dos estados. Ahora, entonces, el primer caso, o lo que vemos con el caso del Mayo, Zambada, es que se está rompiendo esta tregua entre el gobierno de México y Estados Unidos. El caso de los 29 entregados es distinto, porque todos ellos estaban siendo sometidos a algún tipo de proceso penal en México, o incluso ya estaban encarrilado un proceso de extradición, y simple y sencillamente, insisto, fueron entregados a Estados Unidos. El comunicado de México, justificando la entrega, habla de que el fundamento está en la Constitución, lo cual es algo extraño porque la extradición se encuentra en la Constitución. Uno podría argumentar que fue un acto inconstitucional, y la Constitución de Estados Unidos, la Constitución de México claramente dice que está prohibida la extradición de reos políticos, ¿no? Que es un lenguaje muy viejo, pero obviamente entendemos que se trata de perseguidos políticos. Entonces, y el otro justificante que puede ser todavía más preocupante es que también se justificó en función de la Ley de Seguridad Nacional. Entonces, esto nos hace pensar una de dos cosas, que estas personas eran una amenaza para la seguridad nacional mexicana y que era mejor entregarlos. Y ahí se requiere una justificación y una motivación mucho más amplia, ¿no? Sobre todo porque todos los delitos por los que se les estaba procesando o eran motivo de extradición era un tema de narcotráfico, ¿no? Ahora, lo otro es que el otro vínculo posible entre estas personas y la seguridad nacional es el terrorismo. Y aquí México, al aceptar la entrega de estas personas a Estados Unidos y motivándolo en base en la Ley de Seguridad Nacional, hace suponer que está aceptando este reconocimiento de que los cárteles son grupos terroristas, porque ese sería el otro vínculo posible con la seguridad nacional. Entonces tenemos ese escenario que además tiene una serie de repercusiones adicionales. Estamos frente a una manifestación del derecho penal del enemigo, en donde las personas, por lo menos siendo optimistas, solamente las personas relacionadas con el narcotráfico pueden ser entregadas sin que medie la extradición. Eso es derecho penal del enemigo porque se les está sometiendo a un proceso diferenciado en función de un delito del cual se les acusa. Porque recuerden que también hay que respetar su presunción de inocencia y tienen que ser procesados y sentenciados antes de que podamos decir que cometieron un acto de narcotráfico. Y también es otra manifestación de esta disyuntiva entre reciprocidad entre los estados y derechos humanos. Al no ser sometidos a un proceso de extradición, se les violan distintos derechos, como por ejemplo la protección de perseguidos políticos, ¿no? Y esto va muy de la mano del tema de seguridad nacional, porque podríamos verlos también como perseguidos políticos. El tema de la doble criminalidad, que es una manifestación del principio de legalidad penal, que es un derecho humano. El principio de especialidad, es decir, solamente pueden ser procesados por los delitos que fueron materia de la extradición. Eso también queda fuera de la ecuación. Y el principio ne bis in idem. Hay que recordar que muchos de ellos están siendo procesados en México por ciertos hechos, y si son los mismos hechos por los cuales serán procesados en Estados Unidos, pues también. Y aquí requiere un comentario adicional el tema de la pena de muerte, porque la pena de muerte no está prohibida en el derecho internacional, salvo en casos donde expresamente se mencione, ¿no? México ha firmado el protocolo a la Convención Americana que prohíbe la pena de muerte y está prohibida expresamente en la Constitución. Pero volvemos a lo mismo. Al no ser sometidos a un proceso de extradición, México no puede oponerse a que sean eventualmente ejecutados, ¿no? Pero a diferencia del caso del Maya, que hay un pleno conocimiento y pleno consentimiento del Estado mexicano de que deben de ser extraditados, entregados al margen del proceso de extradición. Entonces, la pregunta que nos tenemos que formular es, ante este escenario, ¿para qué sirven los tratados de extradición? Un escenario optimista sería que solamente para el caso de narcotráfico y todas las demás personas sí podrían ser eventualmente sometidas a un proceso de extradición, pero esto nos mete de lleno en el campo del derecho penal del enemigo, ¿no? Entonces, todo parece indicar, y esta sería mi conclusión, de que con esta incipiente práctica, y vamos a ver cómo se desarrolla en casos ulteriores, parece ser que estamos viendo una decadencia en el proceso de extradición en detrimento de los derechos humanos.
Well,
Gracias.
thank you. Gracias. Thank you so much, Professor Dondé. You analyzed the El Mayo Zambada case from the perspective of international criminal law, and I have some words to say about its implications from the perspective of public international law. Because shortly after the extraterritorial abduction of the El Mayo, the Mexican president Claudia Sheinbaum announced the intention of the Mexican government to amend the constitution and recognize for a second time the principle of non-intervention in states' domestic affairs. The principle of non-intervention will be now recognized in two separate paragraphs of Constitutional Article 40 and in Constitutional Article 19. And we must remember that the principle of non-intervention in domestic affairs is also recognized in Article 8910 of the Mexican Constitution as one of the principles which must guide the foreign policy of the state. According to the first new paragraph of Article 40, the people of Mexico will not, under any circumstances, accept interventions, interferences, or any other act from abroad that is harmful to the integrity, independence, and sovereignty of the nation, such as coup d'etat, interference in elections, or the violation of Mexican territory, whether by land, water, sea, or airspace. Pursuant to the second paragraph of Article 40, nor will it consent to intervention in any investigation or persecution without the express authorization and collaboration of the Mexican state within the framework of the applicable laws. The proposed amendment of Article 90 on its part establishes strict sanctions for any person that commits undue intervention in Mexican domestic affairs, pursuant to the new second part of Article 19, to any foreigner who carries out illegal activities related to the second and third paragraphs of Article 40 of this Constitution will be imposed the most severe penalty possible, as well as a precautionary measure of preventive detention ex officio. The initiative to constitutionalize the principle of non-intervention, as I was saying, is a direct response to a growing threat of U.S. interferences in Mexican domestic affairs. In particular, the proposed second paragraph of Article 40 is a response to the kidnapping or the abduction of El Mayo by allegedly, as Professor Dondé were saying, we don't have any proofs, but this kidnapping was allegedly committed by agents of the U.S. government, maybe members of the CIA and the DEA. The beginning of the investigation and criminal persecution against El Mayo was initiated by the U.S. authorities without any express authorization and collaboration of the Mexican state. So, from the perspective of public international law, the extraterritorial abduction of El Mayo is a gross violation of the territorial sovereignty of the Mexican state. Sovereignty's two main features are plenitude and exclusivity. Sovereignty is exclusive because state regulatory powers must be implemented without any foreign intervention or dependency. Thus, Mexico, as the exclusive sovereign, is the only state allowed to exercise enforcement jurisdiction and use coercion to arrest a drug cartel lord on its territory. Unfortunately, as Professor Dondé was saying, extraterritorial abduction is permitted under international criminal law, and it is also a common practice in international relations. The El Mayo case resembles to the Eichmann and also to the Alvarez-Machain cases, as Professor Dondé was saying. In the Alvarez-Machain case, the U.S. government abducted illegally a Mexican national from Mexican territory, and the U.S. Supreme Court considered that the extraterritorial abduction was not an obstacle to submit him to a trial before a U.S. court, precisely invoking the very questionable doctrine of male captus bene detentus. From the perspective of public international law, the extraterritorial abduction of Del Mayo is not only a violation of the principle of territorial sovereignty of the Mexican state, but it is also an undue intervention of the US government in Mexican domestic affairs. The exercise of any kind of extraterritorial jurisdiction, prescriptive or enforcement, directly clashes with the prohibition of interference in another state's internal affairs. The principle of non-intervention in domestic affairs is a general principle of international law, and it is also one of the so-called 5 principles of the peaceful coexistence of states. It was first recognized in a treaty between China and India, and it was later included in many resolutions of the UN General Assembly. However, the exact meaning of the principle is uncertain, especially regarding what can constitute a prohibited intervention. According to Resolution 2131 of the UN General Assembly, no state has the right to intervene directly or indirectly for any reason whatever in the internal or external affairs of any state. Consequently, armed intervention and all other forms of interference or attempted threats against the personality of the state or against its political, economic, and cultural elements are condemned. The principle of non-intervention was further developed in other declarations of the UN General Assembly, and it is also incorporated in Article 19 of the OIS Charter. The International Court of Justice in the 1986 Nicaragua case considered that the principle of non-intervention has customary nature and that the element of coercion defines and indeed forms the very essence of prohibited intervention. As a customary principle of international law, the principle of non-intervention is binding for Mexico and for the US as well, and for all the other states of the international community. Therefore, from a legal perspective, the incorporation of the principle in the Mexican Constitution might appear to be useless because international law is anyway part of the law of the land. However, a closer look to the text of the proposed amendment of Article 40 shows that there are some significant differences between the definition of the principle of non-intervention in the Mexican Constitution and its normative content under international law. Firstly, in international law, wrongful intervention in domestic affairs is normally linked to the exercise of coercion, and the proposed Article 40 of the Mexican Constitution does not include the element of coercion. So any intervention in Mexican domestic affairs, either of a coercive nature or of a non-coercive nature, will be prohibited. On the second place, the list of harmful acts that constitute illegal intervention in domestic affairs under international law comprehends the organization, assistance, finance, incitement, or any other subversive terrorist or armed activities, acts directed towards the violent overthrow of the regime of another state. And under the new constitutional article, prohibited interventions are coup d'etat and, interestingly, interference in elections. This is the first novelty of Constitutional Article 40. It recognizes that an interference in elections, in domestic elections, is a violation of the principle of non-intervention in domestic affairs. There is a current debate surrounding foreign state cyber and other interferences in domestic elections, which started in 2016 with accusations of Russian intervention in the US presidential election. More recently, the threat of foreign interventions in domestic elections arose in the 2025 Venezuelan presidential elections. Many countries, such as Canada, are currently implementing measures to combat foreign interferences in domestic elections. So, by considering interference in elections as a violation of the principle of non-intervention in domestic affairs, the new version of Constitutional Article 40 demonstrates that this principle can actually regulate successively the new problem of foreign interventions in domestic elections. The second innovation of the proposed reform concerns Article 19's recognition of individual criminal responsibility for the violation of the principle of non-intervention. Under international law, the principle of non-intervention imposes duties only on states, their organs, and agents. Therefore, if there is a violation of the principle committed by an organ or agent of the state, the violations is attributed to the state as an entity which can bear international responsibility. Now, under Mexican law, the prohibition to commit interventions in Mexican domestic affairs will be very severely sanctioned, and it will be possible to hold all foreigners criminally responsible for the commission of illegal interferences in Mexican domestic affairs. I think that it is very important in Article 19 to distinguish between the criminal responsibility of an individual for violation of the principle of non-intervention and the responsibility of the state, because normally the entity which violates the principle is the state, and the individuals, in the case of El Mayo, for example, the CIA agents, act upon the orders or under the direct control of the sending state. So, in conclusion, from a legal perspective, the constitutionalization of the international law's general principle of non-intervention in domestic affairs is a very interesting intent to clarify and modernize the normative content of a very old principle of international law, and to clarify its relationship with the principle of territorial sovereignty. From a political perspective, the initiative to include in the Constitution the principle of non-intervention sends a very clear message of rejection of the growing US intervention in Mexican domestic affairs through extraterritorial abductions and other interferences in criminal, migration, and even in judicial matters. But to be an effective response to US interventionism during the Trump II era, the incorporation of the principle in Constitutional Article 19 must be revisited to establish a clear distinction between the responsibility of the state and under international law and the criminal responsibility of individuals under Mexican law for intervention in Mexican domestic affairs. To be an effective political response to US interventionism, it is also important that the incorporation of the principle in the Mexican Constitution is accompanied by some more robust, more strong political actions towards the defense of the Mexican sovereignty, which I consider is very threatened in the current context of conflicts in international relations. It's all from my part. Thank you very much. Thank you very much as well for joining us today. I hope that this first session of the seminar was interesting for you. And I invite you to follow our next meetings, which will be soon broadcasted on the social media of the Law Department of the Ibero-American University at Mexico City. Thank you very much and have a nice day.
Thank you very much. Bye.